Welcome back, everybody. This is Michael Levitas from juristry.com, and I'm back with personal injury attorneys, Gary Silverstein and Jesse Minc. And today we're talking all about construction accidents. What goes into a winning strategy, getting maximum compensation for your injury. We have talked about the investigation required to start a case. Now we're going to talk about actually starting an action for a construction accidents case. And we're going to have Jesse and Gary explain who are the possible defendants, and there are certain provisions of labor law, I believe it's called scaffold law, that are very much applicable in commencing a case. But I'm going to let the attorneys speak and educate us on it. Please.
Thank you, Michael. In connection with starting an action in the labor law context, there's three very important statutes that have different meanings under the law. The first one that Michael talked about is 240 of the labor law, which you referred to as the scaffold law.
Right.
The second one that we're going to talk about is 241.6, which also deals with injuries at construction sites. And the third is labor law 200. So Jesse's going to give us a little overview as to those three particular labor law sections and how that relates to starting an action against the appropriate parties. So that if you are involved in a construction accident, whether you're an HVAC guy, a plumber, an electrician, an undocumented worker, a laborer, whatever division within the construction industry, you're going to get maximum compensation by hiring our law firm. So Jesse, why don't you explain a little bit about the interplay between those three sections of the labor law and starting an action against the appropriate parties?
Sure. So just for background, and so you understand, in New York, there are special rules that protect construction workers on construction projects that don't apply anywhere other than New York. Those are sections 240, 241, and 200 of a rule called the labor law that was enacted over 100 years ago to protect workers in New York. Specifically, when we're starting an action, we want to know, obviously, how the accident happened. That may sound obvious, but the way it happened will tell you not only who to sue, but under what theory. And specifically, which of those three laws I just cited are going to apply and provide you the special protection that the labor law affords. 240, the first one I'll talk about, is involving any what they call gravity-related injury. So if something falls on you or you fall off something, you're probably going to be protected by 240. Then you have 241, the industrial code of the state of New York, which is a set of safety rules established for construction sites, tells you whether or not you have a violation of 241. We're intimately familiar with those codes, and we know right away, hearing a description of an accident, which one to use and put in your complaint to tell the defendants from the get-go what they did wrong. Section 200 applies if there's a dangerous condition on the property that caused your accident, or if another contractor was doing work in an unsafe manner and injured you.
Right.
So with those three rules in mind, we craft a complaint to tell the defendants what they did wrong from the start.
So if a laborer or a construction worker, a plumber, carpenter comes in and says, well, there was only my company, I work for the general contractor, and I was told all I could collect is workers' compensation. Is there any other available parties that you could bring suit if there's only one contractor at site?
Yes, there are. And that's because the labor law puts the onus, meaning the responsibility, on the owner of the project. Whether or not they had anything to do with the work, if they had a rep there, they could have hired the general contractor to do all the work and not come back until the work is done. It doesn't matter. The owner is responsible if there's a violation.
Are you saying that's a non-delegable duty?
That's a legal term. Yes, I am, which means that
mean?
they can't run away from the mistakes of people they hire to do their work. And we make sure that your case falls within that exception, to make sure that even if the owner's not on the job site, they still have to pay for what their agents, their contractors did that injured you.
Okay. Gentlemen, thank you so much for your information. for taking the time from your busy law practice to educate the public on construction accidents and how an attorney can help get maximum compensation for the injured parties. Now, everything we said today, that's just general information for you to know what are the pitfalls. We're giving you general information so you are an informed consumer, informed client. However, if you actually were involved in a case, the best thing to do is call the attorneys that actually do it day in, day out. And one such firm is Rosenberg Minc. Jesse and Gary, they actually live and breathe personal injury law. If you have any questions, please call the phone number on the bottom of the screen. The consultation is free. And please stay tuned. Our next session, we're going to talk about discovery. That's a very scary word. Let's dissect what it means. What does it mean for the plaintiff to get discovery in a court case for a personal injury case? Thank you.